arises that the project that is being run is one that violates the right to clean and healthy environment. So where there is a non-compliance in the procedure of protecting the environment as laid down by the laws, then there is an assumption, or as an assumption arises automatically, that the project is one that violates the right to clean and healthy environment. So that is the that is the section of the Ken Kasinga versus David Kiplagat judgment that is going to guide our discussion tonight. Around that discussion, we are going to analyze what happens when now there's a borderline jurisdiction between the ELC and the High Court. So before I bring my panelists in, I want to engage with you guys on your idea of ELC, even before we go into the technical matters. So the simple question that we'll run through before we bring in the panelists is, in your view, do you think that the ELC has served its purpose 12 years after promulgation of the Constitution? Harry.
Yes, I see it being used very much, and it has made pivotal cases in the development of environmental law. And it has helped to specialize, when we just had the High Court before which article is it? Article 162 further subdivided, or rather delegated, the jurisdiction to the Environment and Land Court. Then we have a better and a swift application of environmental law.
Okay, thank you, Harry. And I agree with Harry that he's talking about court specialization, and the fact that now Article 162 of the Constitution that creates this court has led to promotion of developing or even advancing environmental justice. And I agree that court specialization is an effective tool in developing expertise and in enhancing efficiency in the judicial system. In most cases, court specialization is informed by increase of litigation complex suits and the need to maintain a coherent body of law and division of labor to loosen caseload. So when the Constitution of Kenya under Article 162.2 came up with a system of creating a superior court of the status of the High Court to deal with environmental issues in the time where environmental degradation was highly being witnessed, then we thought that it served its purpose. But analyzing from the facts, we get that out of these issues that ELC deals with, a lot of them are predominantly land issues. And these land issues already found forum in the previous courts, even before a court was designed specifically for environmental issues. So it could be assumed that people are using this court, or the creation of this court, for forum shopping, so that the land issues that they felt would have taken maybe longer time to address in the High Court and the other courts, the other ordinary courts, are now being addressed heavily in the Environment and Lands Court, to the extent that environmental issues are not being heard. So, Hezron, having been in practice, bro, let me just bring in the limelight one more time. What are your thoughts about the efficacy of ELC so far since the promulgation of the Constitution?
Well, thank you, Max, for putting me in the spot again. Actually, currently I am writing a paper. I am trying to write a paper on climate justice in Kenya. And I have been reading about this topic of climate justice. And the concept of climate justice really talks about the fact that climate change came in and it has made it difficult for people who are vulnerable to survive. So you find that people who were poor before have become poorer thanks to climate change. Women who had been affected by society or by the weather patterns the way they were before are severely affected because of climate change. So the concept of justice comes to deal with these things. It encourages that there should be fairness in dealing with the effects of climate change. Now, when you talk about the efficacy of the Environment and Land Court, personally, in my view, I think that it is a key tool in trying, first of all, to deal with the effects of climate change, because it is a specialized court that was created specifically to deal with the large number of cases that were coming in. Before, the High Court had to hear all these cases, but now the Environment and Land Court was created to specially deal with environment and land issues. So that means anything to do with natural resources. that is a very, very controversial topic in this country, has had now a forum. There's a forum for them to be listed that is specialized in dealing with these things. So you expect that the judges sitting in the Environment and Land Court understand things like climate justice, understand things like climate change, understand the issues surrounding natural resources in this country. They understand about the land concept. They are better placed to hear these cases than you would expect if all these cases were just bundled up in the High Court. So I believe, and I've always been a very big supporter of the Environment and Land Court. I do not feel like it is an avenue for forum shopping, because also remember there are so many rules that protect cases from being placed in two different courts. In the Environment and Land Court, their jurisdiction is actually specific. It has to be something that touches on the environment, land, or any natural resource and the crimes that come thereof. So that means if you put a case before there, it has to fit within that category. If it doesn't fit that category, then you can't go before the Environment and Land Court. And there is no way you can go to the High Court and the Environment and Land Court. So I believe, one, it's not an avenue for forum shopping. It was created because there was a need to create such a court, and it has been more, and if that court did not exist. So personally, I think those are my views. It is a very efficient court that has done a lot, and it continues to do a lot with regard to fighting for rights that are surrounding the environment and natural resources in Kenya.
I think
Max, I think you are mute.
Oh, thank you. Yeah, so thank you, KK, for that. So he's a proponent for ELC, and he says even in the composition of the ELC that's governed under Section 7 of the Act of that court, the expertise of the judges that sit in that court is an extra qualification to deal with environmental matters alone. And so it's a key tool towards dealing with environmental issues and also the issue of sustainable development. I just have maybe a different thought or a different view to that I'd like to pose as a question before Marion Irungu picks up and gives us a view on the same. I was doing research on this topic, and the critics of ELC says that the general courts, for example, should adjudicate environment matters. And the reasons why they give for the need of the general courts to adjudicate environment matters is that the general courts are already so exposed to a wide range of legal and complex issues, so they can deal with any legal and complex issue. And they buttress that point by stating that environmental litigation is based on policy consideration, and it is not based on substantive technical data or scientific knowledge. So there is no need for creating an extra court and just using this court to address land issues, because there's statistics, as I said, that in most of the issues that are being filed before these courts, predominantly a large number are land issues and not environmental issues. So the critics for ELC says that in developing environmental jurisprudence and for environmental justice, there is no need of a superior court, the level of a high court, to be created. But the general courts can be designed in a way that a division of the high court is created to deal with the environmental and land issues without creating other additional institutions. Marion.
Hi, good evening, everyone.
Good evening.
From my point of view, I also concur with what Hezron had said, with the importance of the ELC, and also even the same with the employment and labor court relations. And from the findings, at least, that I was able to make, find that, yes, one may argue that, the judges that are already there in the High Court already have the experience and all, but you find that at the same point, or within the same point, you find that also the judges in the ELC and also the employment and labor court relations also have the same qualifications that they are, let's say, specialized in the different fields. And the specialization of the same has helped to even fasten the hearing of the cases, and also from the cases that I've been able to look at, you find that despite people filing the cases for land and employment in the High Court, the same is not struck out, but they are simply transferred to the environment and labor. I mean, to the environment and land court. And for example, to still talk about the same, you find that the ambit was given to, let's say, the parliament was given the authority to determine the jurisdiction of these courts. And the qualification, yeah, I still remain with the point. For the qualification of the judges is still the same, but the focus that has been given to the environment and also to the employment and labor court is important and is necessary. So you can't rule it out to say that it's a way of looking for another forum. And I'd like to bring up a case that was Kenya Medical Research Institute versus the Attorney General and 3 others, which was a 2014 case. And this case, the main argument was that there was a panel of, let's say, 3 judges, where one was from the Environment and Labor Court, but the other 2 are from the High Court. So the argument was that the whatever order they had given was to be struck out because the judges from the High Court were not authorized to listen to the cases from the Environment and Labor. But the order that was given was that despite the 2 not being in the same, like the High Court judges not being the judges who are required to preside over the cases for the Environment, Labor, and for the Environment and Land Court, they looked at in the interest of justice, and the same was struck out, and they said that it shouldn't be an issue to strike out the orders that were given. So you see that you can't, one may still say that the qualifications and also the legal background that both have is the same. There's not much difference, just that there's a specialization, and the specialization is important. And I believe that steps have been taken, and it's a great improvement to the legal system. Yeah.
Okay. Thank you, Marion, for that. We will have a follow-up on all those statements and those issues Marion has highlighted. But just from what she has said, she has brought a point of the former Section 8D of the Environment and Land Courts Act. Before the Environment and Land Courts Act was amended by the Statutory Laws Miscellaneous Amendments Act number 12 of 2012, there was a Section 8D that actually permitted transfer of judges from the ELC, from the ELRC, and from the High Court concurrently. So a judge could be transferred from a High Court to here and determine an issue before an ELRC, and another judge would be transferred from the ELRC to here and determine an issue before the ELC. But people challenged that. People said that that particular section went against Section 7 of the Act that required an extra expertise on the judges that were sitting on environmental matters. And that brings me to a question that I want to shoot to Donald Watson. I know he's already inside. The question of procedure. Donald, what is then the efficacy of this court if this court still uses the Civil Procedure Rules, the Civil Procedure Act, and the laws of evidence to hear and determine environmental matters? What then separates this court from the ordinary courts on environmental issues? Is it just the 10 years experience of the judges on legal study about environmental issues? Don.
Okay, good evening.
Good evening, bro. Good evening.
Okay, on the point you've raised, it's quite a unique point, and you'd understand that previously, I think before the promulgation of the 2010 Constitution, we had the Environment and Land Division of the High Court, which was actually replaced by the Environment and Land Court under the 2010 jurisprudence. And one of the most important aspects of the Environment and Land Division actually of the Environment and Land Court initially before the miscellaneous Statute Law Miscellaneous Amendment Act was that it did not have, the procedures did not have to conform to the civil procedure, rules of evidence and all that. But after the amendment, there was the introduction of the same, of the conformance to such procedures. I wouldn't say it's a bad thing per se, because that is the procedure. We have to, it's procedural law. We have to follow it as it is, in terms of orders, in terms of decrees, in terms of the appropriate documents to file. But perhaps what sets apart these environmental and the land proceedings from any other proceeding is perhaps the provisions of Article, it should be 159, and yeah, on procedural technicalities. And these actually emanated from the decision in the Wangari Maathai case, where they said when filing these matters to do with environmental land, we do not have to conform to procedures and all that in terms of documents. So you'll find that a suit will not be struck out on the basis of commencing the suit by the wrong document, perhaps, or a wrong pleading, so to say. For instance, maybe you commence by way of a plaint rather than a notice of motion, or so. It cannot be struck out on the basis of procedural technicalities. And I think that is the main difference that sets apart these court from ordinary courts. And I say that is a plus for this court, not just the expertise of the judges and all that.
Okay,
even perhaps in terms of locus, you'll agree with me that someone does not have to be at loss or to have suffered the loss directly to institute a suit on environmental degradation or such a thing. So that is a plus as well, yeah, in terms of locus standing.
Okay, and we're coming back to that. I agree with Don. Article 22 of the Constitution of Kenya is clear that even for threat of violation of environmental right, someone has a locus before the Environmental and Law Court to institute a claim on that threat of violation. And so that is a plus, the lifting of locus, that now anyone can institute a legal claim before the Environmental Lands Court, and the fact that you don't even have to suffer harm directly before you institute that claim, that even in existence of a threat you can institute a claim, is a plus of that court. Before we give a forum maybe to audience participation so that we explore on that topic, let's hear KK Mbogo. KK Mbogo is our panelist also today, and is the guy in charge of TOLFF social media. So KK, what's your idea on maybe MCA ELC Act, Ken Kasinga versus David Kiplagat, or on the topic that we're talking about on procedure and the rules of the court?
Hey guys, I'm KK Mbogo. I'm glad to be part of this discussion today. Sorry for joining the discussion late. Just back from Sagana declaration.
Sagana 3. We're waiting for Medinazir at 9 to follow you guys up. Proceed.
Anyway, we all know how important our environment is, and it should be everyone's duty to ensure and maintain a good environment, both for us and the future generation. In 2010, Kenya promulgated a new constitution, and Article 162(2)(b) of the constitution mainly talks about the ELC. Parliament shall establish courts with the status of the High Court to hear and determine disputes relating to employment and labor. A, employment and labor relations. B, the environment and the use and occupation of and title to land. As you can see in the case of Ken Kasinga versus D. Kiplagat and five others, it is evident that the erection of the telecommunication receiver station degraded the environment of the adjacent lands, and the base station had to be pulled down and the environment be restored to the manner that it was before the illegal mast was put up. That was, in that case, that was the ruling by the court, the ELC court. This is a clear elaboration of the ability of the ELC to produce results. Both Marion and Chege have talked about this, so I'll just go to delivery and development of jurisprudence by the Environment and Land Court, ELC. As stated earlier, it is one of the courts contemplated by Article 162(2) as a superior court, just like its counterpart, the Industrial Court. Both have the same status as the High Court. The court is established under Section 4 of the Environment and Land Court Act No. 19 of 2011. It has jurisdiction to hear any other dispute relating to environment and land, Hence, ELC has dual jurisdiction to hear and determine both land and environmental issues. Since it was established back in the year 2012, there is no published data on the number of environmental matters that have been handled by the court as compared to the land. The research carried out by individual and institution indicate that the court has handled fewer environmental cases compared to the land cases. Case loads grants a court an opportunity to settle disputes, develop the stated law and jurisprudence. Despite the fewer environmental matters, the ELC has continued to develop law and jurisprudence, environmental issues such as environmental rights, local standard, and also I think application of international environmental laws principles. Also, it should be noted that across the world there has been an increase in environmental and land courts. Recently, around in 2009, there were only 350 of these specialized court systems in the world. But as we are speaking, there are at least 1,200 courts based in more than 4 countries across the world. This has been brought by an evolving understanding of the human rights and environmental law. This has been brought by an increasing understanding of human rights and environmental law, increased awareness of the threats of climate change, and dissatisfaction with the General Court. This is according to George Pring, a co-author of Environmental and Court Tribunal, a UNEP program for policymakers. It's also normal for humans to prefer specialization, as one of the panelists has said. I've also looked at the data. Chile has the highest number, is the country which has the highest number of environmental cases in South America. And I found out that one of the main reasons why it has a lot of cases, I think it's because the public trust in the court system. Why? This is because it is made up of 3 ministers who 2 are lawyers and 1 must have a science background. You feel me? So basically, they have more trust in their courts rather than just going to give any other judge. You give a judge who is specialized in that specific area. But if you want the most from ELC, we need to change some things. I think we need strong leadership, steady funding, and political support. These are the key pillars to the court's success. Yeah, according to a UNEP report that was written, I think, some months ago. So basically, I'll just highlight all the advantages. I think expertise or specialization. This leads to greater efficiency. It is less costly compared to the general courts. Improved judicial oversight, which leads to public confidence, consistency in decision making, and greater visibility of environmental issues. As much as ELC has a great deal of advantages, I think it's far from perfect. I just highlight some of its disadvantages. For instance, it is hard to objectively judge the value of environmental court system decisions in a world which environmental law evolves and climate change creates new challenges. So the decisions that are going to be made today may not be that good in the next 20 years. So basically, it's not the precedents might be absurd in the near future. There's also the risk of marginalizing environmental courts from mainstream judicial system. And as Ogola said, as we began, insufficient caseload. It's also a disadvantage, and it's also costly to establish new courts. I think the judiciary might need more capital to start a new court. So basically, that's it. That has been my time, and it's KK Mbogo. Thank you.
Oh, thank you. I think my connection also ran countercurrent while you're speaking, but I heard what you said. So the procedure vis-a-vis benefit, economic benefit, is something that we also need to address when we are appreciating the existence of this court or the role that this court has played in developing environmental jurisprudence. However much we might agree, and a large population of you guys might agree, that environmental lands court is very necessary in this moment, now that we're talking about sustainable development and now there's gross environmental degradation. I feel like Kenya wanted to pride itself as being the first country to create this particular court without having the required procedure of creating this court and running it. Because look at it, like the Ken Kasinga case that we are digesting tonight, where booster stamp is being brought down because of lack of public participation. Now, what if the public participation was carried out and they found that actually that booster would have brought more benefit than the complaint that was there before, and the land has already been restored to its original state? Then what's going to happen again? We erect the booster again, or we leave the environment as it is? There are three ambits of environmental law. And before I pose a question, it is very key that we understand this. The three ambit of the principle of sustainable development under environmental law. It is drawn in a triangle where the top is the planet. On one end, we have the people, and on the other end, we have profits. The 3P of sustainable development. That the people has to use the planet to profit from it as we also sustain it. So then what happens? Okay, Ezron has raised a hand and I'll bring him in just right now. What happens where now the procedure of conserving the planet is so strict that we cannot even have profits from that very planet? Ezron.
Sorry, I just wanted to throw a spanner into the works.
Okay.
You mentioned that Kenya was the first country, wanted to look like the first country to set up an environmental and land court, isn't it? It's actually, I don't want to be that person, but it's actually not very true. There are 40 nations across the world that already have environment and land courts. So Kenya is not the first one. It's just one of the 40 that already have specialized courts to do that.
Kenya actually, okay, I get you, Council, and thank you for the clarification. But actually, Kenya was the first in Africa to come up and entrench an environment and land court in their constitution was this proud nation of Kenya. And so it's arguable that maybe in the confines of Africa, Kenya wanted to pride itself by coming up with this court without going through the sufficient procedure of how this court is being run. From where I sit, if out of 12 and 70 cases, only 9 are environmental in nature, and we also acknowledge the fact that environmental courts cannot institute proceedings in their own motions, that for development of environmental justice and jurisprudence, the people have to come to the court with the claims, and in determining those claims, the court has to develop jurisprudence. And for 12 years down the line, I have statistics here. Let me tell you guys real quick that in 2013, the biggest decision that came from the Environment and Lands Court was one. That was the R versus Lake Victoria South Water Services Board and 2 others. When we go to 2014, there were 2 historical judgments: the Adex Limited versus NEMA and Mastermind Tobacco Limited, and the Kome Mwambia and another versus the Dashun Properties Co Limited and 4 others. In 2015, there was no decision on environment that emanated from the ELC. In 2016, there was the Moffat Kamau and 9 others versus the Aulos Kenya Limited and 9 others. That was 2016. Yes, there's the historical Uruvino that was just concluded the other day. So it it could be said that since inception in 2010 and the creation of the courts in 2012, Kenya has had decisions coming from the ELC on environmental matters that are very less than 100. Because the caseload thing that Mbogo says, and Mbogo did his research well, is that there is no caseload from the judiciary on the environmental issues that has been determined. And the reason why they say this is because every decision that comes from the ELC is binded together as an ELC decision. So even keeping a track record of how the jurisprudence has developed over environmental matters in this period of time becomes very hard. So the question is, what is the efficacy of the court if it cannot solve the problem that it came to solve and is just being used as an additional platform to solve land cases that are also being heard in the ordinary courts? Anyone from the audience? Masila. Yes.
What I think, you know,
Yes,
when
sure.
When the Constitution was first enacted in the 20th Constitution, one of the main characteristics of the Constitution is that it's transformative in nature. So it means that even though the land and environment court is functioning yet, I mean the result already is much less than is expected. In the future, maybe more cases will be reported, and also I think awareness with the people. I mean, mostly Kenyans about the environment is still much less. People don't care about the environment, or they're not much aware of the environment. We don't expect them to maybe file cases about the environment, or people first should be aware of the environment. Will not take it soon enough.
So Rono, I get what Rono Abigail is saying, and Rono's blame is not on the court. Rono blames the people. That maybe it is the people who are not informed about the environmental rights, and there is no enough public information about that right. And that is the reason why there is low caseload in the environment and land courts. I'd like to hear another person that supports or have a contrary opinion to Rono. Yes, Don.
Okay, I will perhaps draw an analysis from a decision of the Court of Appeal in a decided case. This is the case of LSK Nairobi Branch versus Malindi Law Society. I think it's a 2016 case which had far-reaching consequences than we can imagine. And I do not wish to proceed on conjecture because I want to draw an analysis to you so that you can understand the implication of that decision. That decision said that the Environment and Land Court does not have exclusive or regional jurisdiction on environment matters. So what is the implication of these of that ruling or that ratio?
That probably the magistrate courts can have the jurisdiction in first instance. Okay.
Exactly. So that the magistrate courts can actually entertain environment matters dependent or reliant on their pecuniary jurisdiction.
Yeah.
So one drawback of these is that we cannot quantify environmental degradation. You cannot say that you have degraded the environment up to 100,000 Kenya shillings. Does it really make sense? It really does not make sense.
Yeah, it doesn't.
It doesn't make sense to me. So, and people will say that that decision was good because it enhances access to justice, because magistrate courts are well located within various areas around the country, so it's easier to reach them. But you'll see that an area suffers grave environmental degradation, but people are not aware because they imagine that it's not that bad.
It's a normal calamity.
Exactly. And maybe if this matter were to be adjudicated before the Environment and Land Court, it will actually be a landmark case that will actually lead to development of rich jurisprudence as well. So I see that as a major issue. And then perhaps just an issue to raise. I don't know. Maybe someone can address it.
Sure.
Is the fact that environmental degradation is cross-cutting, in that we cannot really say that we can only rely on Article 42 alone, because let's say an industry deposits its trade effluents in river. That would mean that your rights under Article 43 to clean water and sanitation is actually violated. So is the same matter that falls under Article 43 to be adjudicated upon in the High Court because of exactly that the High Court possesses such jurisdiction, or since it was as a result of trade effluents, therefore it's environmental, therefore should be adjudicated in the ELC? I wish to get an answer if there is any.
Yeah, there is definitely, and we're coming to that. That was actually my next question, and you brought it in. But before we address it, Santos raised her hand. Santos. Santos. Okay, we lost Santos. I know if she comes back, she'll proceed. So let's go back to Don's question. Don is asking that where a particular corporation emits its influence into a river that is being consumed by a particular amount of residents, then now the right of these people that have been violated is the right to their clean environment under Article 42, and also right to clean water under Article 43. The question that comes in from Don, therefore, is to what extent is the jurisdiction of the ELC and the jurisdiction of the High Court on that matter? We know very well that under Article 165 of the Constitution, the High Court has the jurisdiction to hear any constitutional petition. And that now the jurisdiction that is created under Article 162 for these courts, the Environment and Lands Court to be specific, people say is limited to Article 42, 69, and 70 of the Constitution. But when it is a company actually emitting effluents into a river, then what is the position of the law? Which court has jurisdiction in that borderline? Who would like to pick that up? Chege.
Yes. Now, to give you an answer to that question, we would first need to talk about human rights as they are. Now, it is, of course, understood that human rights are indispensable. You affect one right, you affect another one. So, you affect environmental rights, you are also affecting the right to life, the right to health, the right to, a clean and healthy environment affects other several rights. So, remember, let us remember that the Environment and Land Court is a court of a rank similar to the High Court. Right? So if something is affecting the environment, then that court has the right, or it has the jurisdiction to go ahead and make a declaration on that thing. So if you say that environmental degradation is affecting other rights, that court has a right to speak about that. Now, if you think about the Uwino case, for example, in Uwino, yes, they were talking about environmental degradation, and that was the major right that they were going to court and complaining that these people had dumped toxic waste, and that had affected the people's right to a clean and healthy environment. But at the same time, remember, they also raised the issue of access to justice. And the right to access to justice is a different right from the right to a clean and healthy environment. But then you can clearly see that both of them are interlinked. If these people were told before that someone was coming up to set a company, a battery company, them, they would have never agreed. But then you see, these people came in, they set up, they affected people's health, and it was because they were not told. So you find that to realize the right to a clean and healthy environment goes on ahead to affect several different other rights. And therefore, if you're going to deal with the right to a clean and healthy environment, you have to speak about these rights. So it is true that the Environment and Land Court has the jurisdiction to deal with other rights as well. Yes. So this court is also empowered to deal with those rights. And I think there's a lot of jurisprudence on that already. It's just that I can't find the cases right now, but
Yes.
there's already a lot of jurisdiction on the powers of the court to deal with other different rights, save for the one that it has been specifically reserved for.
Okay, okay. And thank you for that. The environment, I remember I sat in Dr. Wino's class and Dr. Wino said the environment includes everything, including water. Though I'd like to hear another contrary opinion because the jurisdiction of the ELC is clear that the ELC has jurisdiction to the extent of Article 42, 69, and 70 of the Constitution. And as first years would sing it in this platform, owners of motor vehicle Lilian Ness versus Caltex Oil Kenya, jurisdiction is everything, without which a court should down its tools. So what happens therefore if the issue we are addressing under Article 42, 69, and 70 creates an issue that falls under Article 43 or 2021, for example, right to life? Another person before we bring back Don in to ascertain his satisfaction. Santos, are you okay now? Okay, Agustin Orina, I'll take you first, then Ayo will go next. Orino.
So, good evening, everyone.
Good evening, my friend.
Yes, you had asked, let's say, for a contrary opinion. I wanted to look at it this way. We have said that the court derives its jurisdiction from Article 42, 69, and 70. We have the High Court on the other hand, and on this matter, let's say, you can look at it this way. Let's say, where do you think you can get the appropriate relief you are seeking for? The ELC court, what the court can grant in case of an infringement of a right, it's listed under Section 13. Maybe you can look at that, let's say, for under Section 13, and if you find that the relief you are seeking for is not listed under there,
preservation orders, prerogative orders, damages, compensation, specific performance, restitution, declaration, and cost.
Yes, you might find that one, let's say you are involving a corporation like Don had said, you might find that the relief you are seeking for is not covered under the ELC Act. If you go to the High Court can be in a position to grant that relief you are seeking. So I think that you can look at it from that angle. If the relief you are seeking for can be best granted by the High Court, then you go to the High Court and not to the ELC.
Orina gives it the approach of the relief you're seeking, so that you decide the court you're approaching with this issue dependent on relief you're seeking. Ayo's Assemble's hand is up, same as Marion. Ayo.
Yes, thank you, Max Ogola, for having me. And I really have very few points to put across, but what has struck my mind is I think the jurisdiction of environmental and land court has been by and large encapsulated under Article 42, Article 69, and 70. And then of most importance, or what you can allow the Supreme Court about, is stretching the meaning of environment and in relation to life, and the right to life has been extended to the right to a healthy and clean environment, which is really a good thing, read together with Article 21 and 22 of the Constitution as matters of enforcement. And I think the Rio Declaration of 1992 is also important when discerning matters of environment, because it brought about something very important. It encourages state parties to strengthen indigenous capacity building and sustainable development, which sustainable development means legislating or rather acting in a manner that appreciates the current and future generation, right? So that is really important when dealing or when handling environmental land matters. And further, or to elucidate my point, I think also Section 13 of the Environment and Land Code has codified what Environment and Land Code will deal with, which but of the many include matters of biological involvement of anything, natural resources, minerals, and etc. You can mention, the list is too long. and it's clear enough to anybody and to everyone's mind. The jurisdiction of Environment and Land Court has been uh, directly uh, directly provided for. So I think it's out of the question as to whether jurisdiction of Environment and Land Court lies only to which matters or all matters. I think we should just take a succinct view of what has been provided and apply a literal or a purposive interpretation of those chapters, and to give credit where it's due, because statistics shows, and they don't lie, that more than 63% of the cases uh, put forth in the Environmental and Land Court have been expeditiously heard and determined, and within 6 months of petition. So it's really good that Environment and Land Court has to this extent achieved its purpose. Yeah, yeah.
Okay, okay. Ayo says that the Environment Land Court has achieved its purpose because of the expeditious nature of disposal of cases before that court. But on the question we are addressing, Ayo says that the law is clear that the jurisdiction of this court is to the extent of Article 42, 69, and 70 of the Constitution. And then the Act goes ahead to describe what constitutes an environmental issue. So if the definition of clean water, for example, falls under the Act, then the court will have jurisdiction over that. But if it doesn't, and it comes as a result of a violation of the environment, then the court has no jurisdiction to that end. Marion Irungu.
Okay, in a contrary opinion to the same, let's say in spite of the provisions that have been given both in the Constitution and also the Environment and Land Court Act, we find that in the interpretation that has been given by courts in different cases, and I will cite the same, issues have been raised on the issue of incidental concurrent jurisdiction. And this is where, as for example, the case that Don has stated, where you find that a matter can fall in the High Court and also is touching on issues that are also addressed on by the other two courts, which are of the same stature, and that includes the Environment and Land Court. So in instances where the same has been raised, find, for example, I'd give a case of Julius Osea Nyende and two others versus Antoine. Yeah, I'll give, maybe you look at the same. You'll find that in this case, for example, the judge ruled that in matters which are falling within the provision of that section 13, that the court is not only limited to the matters that have been raised or have been stated in that jurisdiction, but it can also enforce the fundamental rights which are incidental to those of which also fall under the Environment and Land Court. And for example, now in this Julius Osea Nyende case, it mainly dealt with employment. And we find that in this case, it was a matter that was falling both under tort and also under employment. So the judge brought out the issue of when you're raising such an instance, you find that the person or the plaintiff who's raising the issue is on to decide whether they'd want, how they'd frame the matter to fall either on to fall, for example, to the High Court as a tort, or also to fall under the ambit of the employment and labor as an employment issue between the employer and the employee. So this was, I put it in relation to the Environment and Land Court because they also cited the same. And in this issue, it was dealt with that the ELRC still had jurisdiction to hear the same because the matter also touched on the issues which were dealt with by the court. So in such instances, you find that the court does have jurisdiction, and the same is already evident in different cases that have been decided upon. So yes, that is my submission.
Nice. From Marion Irungu, we are picking concurrent jurisdictions, and then she tends to lie towards the side of Agustin Orina by stating that now it is upon the plaintiff to frame their suit so that it either falls on the Environment and Lands Court or on the other court as per their need. Kimani Njoroge's hand is up, and so is Weyusia. I'll take Kimani, I'll take Weyusia, then I'll take Ayo and Don. Kimani.
Yes, good evening. These are the exact words of section 13(3) of the ELC Act. And it says, nothing in this act shall preclude the court from hearing and determining applications for redress, denial, violation, infringement, or threat to rights or fundamental freedom relating to clean and healthy environment under Articles 42, 69, and 70. From a plain reading that section, we get that the Act says that its intention is not to prevent the court from hearing. So it is not a preventive act. So it's not a restrictive act. The words of the Act do not restrict the jurisdiction of the court. Rather, as Marion has said, the Act permits or application. The Act permits the court to hear the matters that are incidental to, as Marion has said, because the court says that in the exact words of the relating to, the Act uses the words relating to clean. It does not say that the right has to be the right to clean environment. The rights just have to relate to and have to threaten the right to a clean and healthy environment. Thank you.
Yes, Max Ogola, can I proceed? I think you can just proceed. I think he's busy. Yeah, so Max Ogola, okay, I have a discrete view of what Marion Irungu propounded. And I think it is clear and trite that matters being brought of court of law are of procedural or, in any event, substantive matters. And when they fall within that purview, a court cannot pronounce itself on a matter when it is bereft of jurisdiction. And a matter being thrown out of an environmental and land court is not acting arbitrarily or unconscionably. What matters is whether the procedures of the court are followed because of matters of coherence, clarity, and certainty of the law, which is really important. And therefore, a court cannot pronounce itself on what it doesn't have. And throwing out a case is a matter of procedure rather than substance. As many cases have been decided, it is substance which will.
Ayo, let me cut you short in a minute, my friend. We have like 6 minutes to conclusion, so let me take this procedurally before we come back to you. Will you say your hand is still up on the same topic before I give you and on?
Okay, thank you. I hope I can be heard.
Yes, now you're audible. Proceed.
Okay, in response to whatever Don had asked, whether the Article 43 of the Constitution can come in under the jurisdiction of ELC Act. When you look at Section 13, subsection 2 of the same Act, Part A, it enlists a very large clause of and we have natural resources as part of the disputes of the matters that the court can hear and determine. We all know what natural resources are. You can look at Article 260 on interpretation, and you'll find that water is included in the list of natural resources, and we know that water is actually a natural resource. just echoing what Kimani had said on the issue of rights relating to a clean and healthy environment, I agree that actually you can raise Article 43 on the right, specifically on the right to, is it water, adequate water, something of the sort, in case of pollution in how do I say it, in the ELC court.
All right, thank you, Ms. Weyusia. Yes, Ms. Weyusia is addressing the point that Kimani also said, that Article 32, Section 13 of the Environment Lands Code is broader in the concepts or on the issues that the court can have jurisdiction upon, and water falls under natural resource. So the way we were saying, if it's an interdependent right to a clean and healthy environment, then this court will have jurisdiction to hear and determine it. Keep Koech, you'll be the last I'll take on that topic before proceed, bro. Unmute. Or maybe Keep Koech just left. He raised his hand. So if he comes back, yes, Don.
Yeah, I think I've heard the diverse views from the members, and I wish to say that I'm not quite sure which one, which school of thought is actually accurate, but one of the justices of the Environment and Land Court, this is Justice Oscar Ngote of ELC Machakos. In a paper he wrote, he actually cites the issue of forum shopping as one of the challenges affecting ELC. So, if we allow for matters to fall within the environmental matters that actually touch on other rights to fall within the ambit of the High Court, wouldn't we be opening the floodgates to forum shopping, in that I do not have to go to the ELC, I can just go to an avenue which has the best reliefs and such a thing? And he cites that as one of the challenges that face the court in terms of even developing its jurisprudence.
Yeah. I read that as well, the forum shopping issue, and that's why I was also not leaning towards the point of framing points to favor the reliefs that you're going to obtain before court. Jurisdictions of court flow directly either from the Constitution, statutes, and are clarified by precedents. So when the statutes and the Constitution is clear on what a jurisdiction of a court entails, that is the scope to which that jurisdiction ought to end. The last question I'd like to pose to all the panelists and also the members in the discussion, so that we look at it critically, is that the interpretation section of the Environment and Lands Codes Act in Article 2, in Section 2, that is the interpretation section, deletes the creation of a principal judge and replace it with the apposition of a presiding judge. Those who have been in practice, few of us in this discussion, and I know Don, you've been in practice, a few were used here, Chege was in here, has been in practice. We know that ordinarily the position of a principal judge is higher than the position of a presiding judge. So if the ELC is headed by a presiding judge and the High Court is headed by a principal judge, then the question of equal status under Article 162.2, does it make sense? Don.
Yeah, thank you. I think that is actually a major issue, and that provision under the interpretation section was deleted by the Statute Law Amendment Act of 2012, and the same Justice Angote actually cites it as a very contentious issue because, for one, it means that the ELC does not actually have the same status as the High Court, because initially we had the principal judge, then they deleted the section without need for public participation, just as a miscellaneous amendment. And I think that is quite an issue, it's only issue, because we are actually still treating the ELC as a division of the High Court, since that would mean that perhaps because presiding judges report to principal judges, who then report to the Chief Justice. But I will argue again on the other side and say that it still creates the presiding judge who shall still be answerable to the Chief Justice. So it's quite a contentious issue. It has not been dealt with clarity, and I think I will fence it on that one, but I will lean more towards the concept of it actually undermines the status.
As Don sits on the fence on the status of the ELC and the High Court, because the principal judge and the presiding judge is, yes, a contentious matter. Let's hear what UC has to say on the same. Audrey. Audrey, your hand is still up. That's why we are calling you in. But if maybe you are not in a position to pull back in the interest of time, are you?
Yeah, thanks, Max Ogola. Actually, I don't know why there is a furore on this matter, but I think it's clear enough as the day that the Environment and Land Court is a court of same status as the High Court, and that's why the Act deliberately expunges an appeal that will expunges High Court in matters appeal, because appeal will lie directly to the Court of Appeal rather than passing through the High Court, meaning it has been omitted intentionally, not because of anything. And we need to also consider that Environment and Land Court came about to supplement rather than supplant the position of any court. Therefore, of importance is what the judges pronounce rather than what the law provides, because
I don't agree with you, and I'm just going to cut his opinion in short before he even proceeds for the purposes of recording this platform. The issue of appeal is a whole different thing, and we don't want it to mislead the public or even law students listening to this based on our ideas. There's a hierarchy of judges, and a principal judge sits on a very top position than an ordinary presiding judge. And the constitution is clear that the ELC is a superior court of the same status of the High Court. So let us not run it through that maybe other people somewhere thought better than we, the Kenyan people, ought to have thought. And we also know that the Statutory Laws Miscellaneous Amendments Act came into force without public participation. So there was not the people of Kenya's idea on that particular amendment. And it's a very key issue in determining that we cannot rush through. So keep quiet, please. Check real quick. Keep quiet, your hand is up. Are you? Just mute. Keep quiet.
Okay, I think Max, you can confirm whether you can hear me.
Audibly.
Yes, sorry I lost you earlier on, and I wanted to weigh in, and I don't know if time can allow me to briefly weigh in before I say something on on the issue of the presiding judge and even the principal judge.
Sure, take your time.
Yeah, so I've been following this discussion, and I think the main reason for the establishment of the ELC is to promote access to justice under Article 48. I know that's a new input into the discussion, but that's my feeling and that's my thinking on the same. And it's for the reason that has been raised earlier on the issue of specialization of the courts. Because looking at what has been happening earlier on before the 2010 Constitution, and even what is happening now, should there be no specialization, then you can be guaranteed that there is not going to be a service of justice, and especially when it comes to such matters as the environment and even issues to do with land, where there is where the ELC has been given that specialization. And on the issue of jurisdiction, I think the law is clear on the same. The Constitution is clear on the same. And as has been said, that's under Article 162 2B. And ELC is to handle matters touching on environment and on land. So any other matter that's falling outside that is not to be handled by ELC. And my point is that the Constitution is clear on on the issue of jurisdiction, and also remembering, or yes,
Right.
remembering what they said earlier on. Yes, Max.
Listening to your submission, bro, I like them, but we have less than 5 minutes to conclude, so I'd give you a minute, bro. Proceed.
It's okay, no problem. Yeah, so something else is that on the when it comes to the jurisdiction of both the High Court, the ELC, and the ELRC, these courts are there to complement one another, because as has been said, and constitutionally they are of equal status, and they are not competing with one another, but they are there to complement one another. So anything that falls outside the jurisdiction of ELC is to be handled by either the High Court or the ELRC. So that's the point. And I think the last thing is that these provisions are people-centered. When you look at the Constitution entirely, these provisions are people-centered, and they are human rights centered. And from my point of, from where I sit, I want to believe that each and everything, or the move that will, in the best way possible, address the human rights and resolve the disputes by the, or resolve the dispute, is to be taken by the court and not otherwise. And on the last issue of the presiding and the principal judge, just 10 seconds. Anything that tries to contravene the Constitution, I think it has to be challenged. Its constitutionality has to be challenged, and there is not supposed to be. These courts are of equal status, and anyone who purports, or any law that purports to elevate one over the other, I think it's unconstitutional, and it has to be brought down based on that. Thank you so much. Yes, thank you.
Thank you, Great. I think you just tell us where you're joining us from, which campus, maybe?
I'm from Moi University, Annex Campus.
Oh, thank you, Kikwet from Moi University, and thank you for joining the discussion. Today, we were dealing with the overlap of jurisdiction between the ELC and the ELRC. Our case study was to be Ken Kasinga versus D, Kiplagat, and 5 others. The key issues that we were rotating about was: 1, as the ELC served its purpose in developing environmental jurisprudence and making access to environmental justice. 2, does the ELC function ordinarily if it is still subjected to civil procedure rules and civil procedure act and laws of evidence, or should the ELC have its own system of procedure and rules as was earlier determined by the people upon its inception? The third issue we were dealing with is the ELC of the same status as the High Court. If the principal judge is in the High Court, yet the ELC is being held, is being led, with a presiding judge. This, among other issues that we discussed tonight, form the basis of our last case digest on overlap of jurisdiction this month. And as we start the month of March, we will be dealing with alternative dispute resolution cases, ranging from the Nyoto decision to the synergy decisions and all the issues in between. We thank you again, just like every other day, for making time and being with us tonight. We wish you a good night, and we wish upon you God's favor until we meet again next Wednesday. We have 1 minute to conclude our digest, and that will be a free time to any of you who has an additional contribution. Thank you and have a good night.